Good morning. Welcome to the webinar. This is Roger Royse, and today's presentation is Protect Your IP. As you know, this is one in a series of webinars that we do here at Royse Law Firm. Every other week we have a presentation on topics of interest to the legal and business community. And today we have two speakers to discuss issues around IP and patent strategies and generally protecting intellectual property with an emphasis on recent developments and what's changed and what's new. The first speaker is going to be Neal Marcus. He's a patent lawyer with the Marcus Law Firm here in Palo Alto, also with an office in Chicago. Neal has 20 years of experience in patent law and practices primarily with high-tech medical devices and clean tech. Our second speaker will be Satya Narayan, who will be calling in from India. She's a licensing and commercial contracts lawyer with the Royse Law Firm here in Palo Alto. The Royse Law Firm is a general corporate business and tax law firm with offices in Northern and Southern California. We service primarily the high technology industry with special emphasis on startup and middle market companies. So I'm going to go ahead and now housekeeping matters. You should have on your screen now the slide presentations for Neal. To start with, you'll notice in the upper right-hand corner there's a text box. If you have questions, please type your questions into the text box. If we have time at the end of the presentations, I'll ask the panelists to go ahead and answer your questions. And for now, I'm going to go ahead and turn it over to Neal.
Thank you, Roger. Thanks for letting me speak here in the Royse Law Firm. It's a lovely day here in Silicon Valley. My choice of topics is hot topics in IP and the patent side, and there are many choices. One could talk about the mobile device wars, Apple versus Samsung. We could talk about non-practicing entities, the trolls out there who are basically suing everybody and going after everybody who are not practicing anything. And there's topics of design patents, which is another hot topic. But today, I want to talk to you about the America Invents Act. It's the act that was signed into law in 2011. It's by far the most expansive, intense law that we've seen in the patent world, and will probably have the most effect on the patent system for examination and so forth for now and for the future, for at least probably another 10 years. I doubt that there will be another law that will change. Typically, that's how this works. But on the American Invents Act, we're not just going to talk about all of the American Invents Act. We're going to talk about the Firsttofile system that's coming about. It will change the dynamics of patent law, and if you're entrepreneurs, you are startups, this will have a huge impact upon you. The large companies, it will too, and the universities, but the large companies do have a fair amount of resources, and we'll talk about that in a minute. Okay, now to go on here. Okay. Yeah. What I'm hoping to get out of this today and discuss, what are the Firsttofile basics? I want you to walk away knowing what they are. I'm going to talk about examples. We're going to get into it. I always felt that the law as an abstract doesn't mean a whole lot unless you actually apply it to specific circumstances. So we're going to get into some examples of the Firsttofile system. Then I'm going to talk to you a little about how it affects patent strategy, and then ultimately how to maintain IP protection on patents and my recommendations in light of it. I'm also going to get into patentability. The Firsttofile system and American Invents Act did change what constitutes patentable information that can be used against you during examination. It broadens the scope of it. Things change with that, and we're going to get into that topic as well. But first, I feel in order to do that, I think we need to get into some of the basics of patent law. I call it Patent Law 101. There are probably many of you out there that have a fair amount of knowledge in the area of patent law, and I've probably got 5 slides to go through and talk about some of the basics. I want you have all, if you're very skilled in patent law, bear with me, but I feel for those who are sort of first-timers and sort of new to it, I think it's important that we get into some of the patent law basics. They're called Patent Law 101. And I'll try to go through it fairly quickly. All right. As you see on your screen, what is a patent? What rights does it give you? What a patent gives you the right to exclude others in the U.S. from making, using, selling, or offering for sale or importing a product that incorporates your patented feature. Okay, I'm going to repeat that again. It excludes others from making, using, selling, offering for sale, or importing a product that incorporates your patented feature. Now, it doesn't mean it gives you a right to make a product yourself. You can make a product yourself, and it includes a feature, your own feature that you have patented, but that product could have multiple features on it covered by multiple patents that are owned by multiple companies. This seems to be a concept that's hard for a number of inventors and entrepreneurs to grasp. All it does, as I say, the patent owner has a right to exclude others from making, using, selling, offering for sale, or importing products of others that incorporate your patented feature. Okay? All right. The patent contents. Okay. What's in a patent application? What's in a U.S. patent? And a utility patent, by the way, and maybe it's worth breaking that down a little bit too. There are two types of patents that we have. A utility patent, which covers the function of something, features, how things work. And there's a design patent that's out here. It covers the way things appear, the aesthetic looking features of it. Today we're going to pretty much discuss utility patents, but design patents are also a topic, at least for another discussion. And in a utility patent, there are basically 4 different elements in it. If you look at a patent, I don't have it in front of me, although I do have an example in a second to show you on another slide of one of the sheets. It has 4 things. It has an abstract, and that's usually on the front sheet of the patent. And it's a short summary of the invention. It's a paragraph form. There's usually a limitation on how many words you could have in it. They used to use abstracts for searching in the older days. It's a good summary, hopefully, of what the invention is and what you're trying to accomplish, so someone can get a quick look at the patent and get a flavor. Now, there's usually a set of drawings. These are illustrations of the variations of your invention. There could be many drawings. I've seen cases that have, 50 pages of drawings. Anything that's going to help describe what you're trying to do. Now, the other topic, the other element of patent is a detailed description, and that's exactly what it is. It's a detailed description of the invention, how it's used, all the variations of it, and this description will also refer to the drawings. So they work together, the drawings and the description. Okay, and you want to give the examiner sufficient disclosure, sufficient information to teach somebody, arguably who's skilled in the art, as we would say, someone who's skilled like you, how to make it, how to make your invention. If they read it, they can look at it, they can probably build it. Okay, and the last thing that's in a patent is the claims. This is the most important part of the patent. All right? This is the most important part of the patent. Claims are in the back. They define the scope of protection for your invention, the coverage. Let me give you an example here. All right. Here's an example you'll see on this slide, if you see in front of you. This is one patent, a sheet of one of the patents. You can look at the patent number 8190519. Believe it or not, I think this is a Facebook patent. I didn't put together all the sheets, but I wanted to give you a flavor of what these claims look like. They're numbered paragraphs. They're at the rear of the patent. You see where that arrow is? Those are the patent claims. Now, here's the thing. We talked about what a patent gives you, a right to exclude others from making, using, or selling. That means it's the right to exclude others from making, using, or selling the invention defined in these paragraphs, in the claims. If the subject matter is not in these claims, you do not have coverage for that subject matter. You could have a 400-page patent and have 2 claims in the back. And that 400-page patent application could have a description of 25 different features. Each of them potentially possible you could get claim coverage for But if you only went for one invention, which you're supposed to in one patent application, you're only going to have coverage for that invention, and that's that. I'll say it one more time. If it's not in these claims, you don't have coverage for it. All right? This is going to come back to us a little bit later, but you need to know what claims are. And claims are a very specific thing. It takes a fair amount of skill to draft them, and how it should be covered, and different variations of coverage, whether it's a software, whether it's a surgical method, a surgical device. It could be hardware, computer systems, networks. There's very different variations in how one can claim, and it takes some skill to do that. Okay. All right. What does it take to get a patent through the patent office? What are the requirements? And the requirements, there's really basically 4 of them. There's other specifics, but I distilled it down to these, and this is sort of at the crux of it. It has to be eligible subject matter. It has to, it could be a process, a machine, a manufacturer composition. For example, hardware, software, surgical devices, implanted devices, drugs, pharmaceuticals, methods for making the pharmaceuticals. All right? Business methods are covered. All right? You have to be the original inventor. That's new under the American Inventors Act. Before, you used to say that you were the first inventor. And we're going to talk about that a little later. All you have to be is the original inventor. All right? The patent application has to be new. The subject matter has to be new, unique in view of what has been developed before. That's the test. It's new. Novelty is what we call it. And it also has to be unobvious. Now, this is a test that is very difficult for many of the courts. It has to be unobvious in view of what's been done before. It's a very subjective test. Some of the case law that's come out, if you ever heard of KSR, it's a recent, not a recent, but a reasonably recent case, and talks about this. It's whether something achieves a predictable result, they say, can potentially obvious. The bottom line is this is a very subjective test, and it can be subjective in front of examiner to examiner to examiner at the patent office, including judges. It's been a constant thorn in many people's rear that they don't know how to handle the test. So partly because it's so subjective, but it's supposed to be unobvious, and these are the basic tests for patentability. Okay. Let's get into the Firsttofile system. This is more into the guts of it. Okay. What is the current law today? The current law today is the first person to invent. If you invented it or conceived of the idea, your concept first, you should be entitled to a patent. That's the law in the U.S. today. Obviously, provided you didn't abandon it. And what does it mean to abandon it? If you decide that you came up with something and then you worked on something else and put it on the shelf for several months or a year, that would be maybe considered you abandoned it to a point until you picked it up again. But the idea is the person who conceived of it first should, in theory, should win. The filing date of your patent application does not ultimately control this decision. It helps, but it's not the final control over what goes on. Who conceived of it first and who spent their time pursuing a patent and trying to develop it and filing a patent application. And usually these disputes are decided in what we call an interference proceeding. It's done at the U.S. Patent Office. And typically the USPTO, the U.S. Patent Office, can initiate what we call an interference, or the applicant can get wind of another competitor's patent application because they come public, and they can try to invoke an interference proceeding. These proceedings are very long, they're quite complicated, and they're incredibly expensive. It's basically like a litigation. And you take depositions, and I've been through them before. They take a long time, and they can be quite a drain on finances. And if you're a startup, or you're an entrepreneur, chances are you're not going to have the kind of money to pursue this. So from that perspective, interference proceedings can be a bad thing. But it is the only way that they know today to actually determine who is the first to invent. Okay. Now, under the Firsttofile system, or Firstinventortofile, this is the final phase of the Act. The most expansive, I think, and the most intense part of the Act, in my personal view. There have been a number of phases that have been passed already. This is the last one. And if the effective date is March 16th, 2013. For any applications filed on or after the effective date, which is March 16th, 2013, we're now going to award patents to the first inventor to file. Does that make sense? The first to get to the patent office and file their patent application for the idea should be awarded the patent. The filing date controls. It does not matter who invented it first. So you could have come up with an invention a year before somebody else, but if you waited on it and you didn't file a patent application and someone else did and they rushed to it, they're going to win. And frankly, you're probably going to get a little upset about that. Interference proceedings go away. There's no more interference proceeding after March 16th, at least for new cases. This is a good thing and probably a bad thing. Obviously, from a cost perspective, it will remove costs, but it ultimately gets rid of the inventorship issue, which, in my view, sort of hurts the small inventor, the entrepreneurs and startups, and I'll chat with you all about that in a little bit. This particular law, the Firsttofile, now makes our system, once it gets enacted, once it goes into the final phase, more consistent with the international community. Europe, Japan, almost every that I'm aware of is on a Firsttofile system. We are the final country to go dragging, kicking, and screaming into this system. Okay. Now, what about patent applications that are filed after the effective filing date, but it actually claim priority to an earlier pending application that was filed before the effective date of March 16th? It gets more complicated. The question of what system would you use, is it a first to invent or a first to file system, will depend on two factors: what the claim coverage you're trying to receive, and whether there's support, subject matter support in the original case, the earlier case. The bottom line here is the later filed application is subject to the first invent system, provided the claimed invention is supported by subject matter from the earlier application. So if that earlier application has a proper description about the feature that you're trying to claim in the later case, it will be determined under the first to invent system. Okay. I think now it's probably worthwhile getting into some examples. This is a law that, while seemingly it seems fairly easy, but it can get kind of complicated. So let's get some examples. All right. Example one. You know the people from Yelp and City Search. These are two companies. Yelp is a publicly traded company. I don't know if City Search is, but anyway, the example is Yelp filed an application on January 1st, 2013. They came up with an invention. They claim it, and the claims, as we talked about before in the paragraphs, that features A, B, and C. They are trying to get coverage for A, B, and C. They invented it December 15th, 2012. City Search, on the other hand, filed the application on March 15th, 2013. The invention claim is also the same invention, A, B, and C, and they invented it in November 12th, 2012. The question is, what system do we choose? What is the proper system that's going to be used to determine who should get the rights to this invention and who should win? Any thoughts on that? If you pick City Search, you would be the winner. Well, let's go through this. This is a fairly straightforward situation. Both cases were filed before the effective date, March 16, 2013. So this would be judged based on the first to invent. And City Search invented it first. They came up with the November 12th, 2012, about roughly a month before Yelp did. So in theory, City Search should win this battle. Assuming they didn't abandon it, there's obviously going to be interference proceedings on this point, and who should win. and it'll be a little litigation, but in theory, City Search should win. This is a pretty straightforward situation. Okay, example two. Example two, you've probably heard of Uber. Uber is the taxi cab service that's been infiltrating many cities and so forth, and gotten a little bit of press because a number of cab services have been too thrilled that they just came into their city and started a service without getting registration with the city. It's a good little service, and this is with Taxi Magic, which is another application, another company with an application out there. Let's hear. Here's an example. The Uber filed an application March 20th, 2013. They claimed the invention A, B, and C just like before. They invented it December 15th, 2012. Well, Taxi Magic filed the application May 15th, 2013. They invented the same concept, features A, B, and C, and they invented it May 12th, 2012. Which system do we use, and who should win this battle if there's a dispute under the same subject matter? Well, if you chose Uber, you would be correct. And this is fairly straightforward. Both applications were filed after the effective date of March 16, 2013, where the first-to-file system takes place. So this would be judged in the first-to-file system. Uber filed first. Doesn't matter who invented it. So Uber should win this battle. And it should be fairly easy for Uber to win this battle. There won't be interference proceedings. It seems to be fairly straightforward. All right. A couple more examples. Example 3. You're probably familiar with Groupon. Groupon is another a fairly sizable company now out of Chicago, my hometown. Let's say this is a little different example. Let's say Groupon filed an application. They filed it January 1st, 2012. Let's say they filed a provisional application. If that's a term that you're not familiar with, a provisional application is an application, a U.S. process that you could file that doesn't have very many formal requirements at the patent offices to give the inventor a fairly easy way to file a patent application without having to go through real formal requirements. But within 1 year, you still have to file a non-provisional in order to pursue a patent. But it gives you the opportunity to put a stake in the ground. Okay, let's say Groupon files a provisional application January 1st, 2012. Actually, it wouldn't be a provisional, January 12th. Okay, let's strike that for a second. It couldn't be a provisional because Groupon filed the second application more than a year before. Let's just say that's just a general application. It's not a provisional. Same thing. They filed it January 1st, 2012. The invention disclosed, let's say that it was claimed as well as described, features A, B, and C. Same as before. Groupon decides to file a second patent application on May 15, 2013, which is after the effective filing date of the first-to-file system. And the second case claims priority to the first. They claim the invention A, B, and C, which is the same. The question is it going to be judged on the first-to-invent system or the first-to-file? Well, the bottom line is application 2 was filed after the effective filing date, but it claims the same subject matter that appeared in the first patent application filed before the effective filing date. Therefore, since it's not claiming anything new, it would be judged on the first-to-invent system. Does that make sense, everybody? On the first-to-invent, application 2 would be judged based on the first-to-invent, even though it was filed after the effective filing date, because it's claiming priority to subject matter in an earlier case, the exact same subject matter in the earlier case that was filed before the effective date. This is a bit of a complicated issue, but let's go on to example 4. This is the last example. You know everybody, you know all about Apple. I don't think I have to describe who they are. Let's say application 1 was filed January 1st, 2012, before the effective filing date. The invention disclosed and claimed features A, B, and C only. That's it. It covers A, B, and C, and that is it. Apple decides to file a second application on November 15, 2013, which is after the effective filing date, but it claims priority to application 1. But in the second application, the invention claimed in those numbered paragraphs features A, B, and C, and it includes D, which is a new feature. Which system would be used, the first to invent or first to file for the application number 2? This would be under the first to file system. If you guessed that you'd be correct. And the reason is, the second application is trying to claim additional subject matter that is not found in the original case. The original first case, application 1, only claims features A, B, and C. It does not include D. And because D is now in the second application, it's going to be judged on a first to file system. And any other case that follows will be judged on the first to file system. Once you turn it into a first to file case, forever going back. The issue comes down to what is claimed and the subject matter supported in application 1. That's ultimately what determines these issues in all cases. All right? All right. One more topic here on the first to invent that's going to be going into effect March 16th, and the effective date is what constitutes proper information that the Patent Office can use against you when you're going through the Patent Office through examination. And some of the rules. It broadens the scope of the available information that can be used against you. What's unchanged? If the inventor himself or herself publicly discloses the invention, or a third party discloses the invention but derives it directly or indirectly from the inventor, that inventor has 1 year to file a patent application in the U.S. It's a 1-year grace period, and that hasn't changed. That hasn't changed at all. What constitutes derived directly or indirectly from a third party? That's going to be a complicated issue for the courts, and I'm not going to get into that today. But what has changed? All prior public disclosures can prevent patentability before the filing date of your patent. Before, you had a 1-year grace period. Now you've got no more 1-year grace period. If some third party discloses your invention in a publication or a public use or a sale activity anywhere and at any time before the filing date, it doesn't matter. Before, if you publicly used or put it on sale somewhere else outside the U.S., it wasn't a big deal, and you had a 1-year period of time, a grace period to file if the public use or the sale was in the U.S. Now you don't. So anything done before the filing date of the patent application can hurt you. Not only that, the Patent Office can use foreign priority dates. If someone filed a case here but claims priority to a foreign country that was filed earlier, let's say in Europe, they can use that date if it has the subject matter in it. Historically, under the old law, they couldn't use it. It makes it more difficult for the patent owner. All right. All of this discussion, what is the effect on patent strategy and so forth? You know, I go to a number of committee meetings. AIPLA is a national organization, the Intellectual Property Law Association, and they have an emerging technologies group as well as a lot of other companies, a lot of other organizations. And we pretty much all come to the same conclusion that the first to file system is overall it's unfavorable to entrepreneurs and startups. It is. The reality is, you know, any delay in filing will jeopardize your patent rights. If you don't sufficiently disclose your idea in a patent application, will jeopardize your patent rights. And arguably, it will increase your costs for filings because you don't have time to spend thinking about whether you're going to file. You can't dilly-dally around. The bottom line is you're going to have to file it as quickly as you can. And that's very difficult for entrepreneurs and startups. They have limited budgets. I've worked with them quite a bit. And they're going to think to themselves, well, how many applications can we really file when we have to pay our employees? We need to develop a website. We need to develop a mobile device, an application on your mobile phone. This is really very hard for entrepreneurs. Overwhelmingly, I think the patent attorneys and the community take the position, although the Patent Office probably doesn't. I've spoken to one senior person that said that they disagreed with me, but she was fairly senior at the time. It's not favorable for startups and entrepreneurs. All right. We're almost done here. How to best maintain IP protection and my recommendations on this. If you haven't done so already and you're a startup, you're not going to need a committee. You're going to have 1 or 2 people or 4 people. But I would get a committee together and you prioritize your invention. You make a list of all your ideas and your concepts, and you focus in on key inventions. You're going to go for the current and the most immediate features to go pursue. If you got the budget to file provisional applications, I would do so, covering with the best disclosure. If you can, file applications before the effective date of March 16th to ensure that you're going to be judged on the first to invent system. If you have to do it afterwards, the effective date, you're going to need to file these applications very quickly. You can't sit around. And these applications that you file, which to me is no different, you should be filing complete disclosures. Describe your things very well. Now, if it's a software application, if it's a mobile app or network, it really requires a bunch of flow charts. If you can get a very solid set of flow charts and some basic description down and file the case, you already have your steps already there. You've helped yourself out by getting that on file. A flow chart, if you're software people, speaks 1,000 words. And the more you can put into your disclosures, the better. You can get provisional applications and cover multiple features. You can put them all in one if you wish, or you can consider filing serial provisional. If you file one and as you develop your product, you can file another and file another as soon as you come up with new features. Because in theory, provisional applications, the cost at the patent office is not that expensive. It's $125, I believe. Maybe it's gone up. These costs go up quite a bit. Those would be my recommendations. I would get on moving. It's in a month and a half. And I guess it would left up to any questions.
Thank you, Neal. We do have some questions, but before we get to that, maybe we'll check in with Satya. Satya, are you on the line yet?
Hey, Roger. This is Satya here.
Okay. Why don't we have several questions on the patents, but why don't we go ahead and proceed with, if you can load up Satya's presentation, we can proceed with Satya's presentation on some of the licensing and IP concerns. While that's loading, Neal, one question we got is somebody asked whether software patents were hard to get these days. Do you have an opinion on that?
Well, software patents have changed over the years as far as their difficulty in obtaining. Right now, the Patent Office seems to be fairly open-minded to software patents. Kapos, which is the Commissioner of Patents, has spoken many, many times, although in the next few days he steps down. He's very for software patents. They're much easier to get today if written properly. It takes a bit of skill to write them from a claim coverage perspective, but they're easier today than they were 5 years ago, 6 years ago. I represented one client, and it was very difficult. We always would get these rejections under Section 101 as not proper subject matter. But today, it's a little different. They're easier to get through the Patent Office, hopefully with some decent coverage.
Okay, thank you, Neal. So again, I'd like to reintroduce Satya Narayan. She's a licensing, technology, and commercial contracts lawyer here at Royse Law Firm, and her presentation is on more of the different types of intellectual property strategies and defenses. So Satya, your presentation is loaded, so I will let you take it away.
Thanks, Roger, and thanks, Neal. Good morning to everybody who has called into the conference. So I'm going to talk, if you can just move to the second slide, the scope of the presentation. Today I'm just going to talk about 4 pieces here: types of IP, some IP monetization strategies, some additional IP strategies, and some licensing restrictions and issues, and then we'll conclude. So next slide. Types of IP. So today's focus is primarily on copyright, patents, trademarks, and trade secrets. I will not be focusing too much on the patent side, as Neal has taken that part of the presentation very well, and I don't think I need to fill in anything over there from my side. So next slide. We'll start with copyrights. So copyrights are essentially, they protect original works of authorship, including software, which is considered a literary work, dramatic, musical, artistic, architectural, and audiovisual works. A copyright arises the moment the work is fixed in a copy or phonorecord. Essentially, the moment you write source code, for instance, and you put it down on paper, that's the moment when the copyright arises. You do not need to secure any registration for your copyright. There are certain benefits of securing copyright registration, but that's really more in the entertainment world. In the software world, you don't really see people registering their copyright, except before filing suit, an infringement suit. So, as I said, copyright is secured when the work is first fixed in a copy or phonorecord. The copyright gives you essentially the right to exclude others from, it gives you the exclusive right to reproduce, create derivative work, which is essentially modifications, exclusive right to distribute, and publicly perform and publicly display the work of authorship. Your copyright, by virtue of the International Berne and UCC Convention, gives you protection under the Berne Convention in 164 countries and under the UCC Convention in 100 countries. The U.S. is a signatory to both those conventions. The basic protection tips when it comes to your copyrightable work is, again, no need to register it, so we don't have that angle, but definitely include a copyright notice to the work, which is typically in the form of, the word copyright or C in a circle, the year of first publication, and then your name, the name of the owner of the copyright. So it would be something like C in a circle, 2013, Jane Doe. What that gives you essentially is, if somebody copies your work, so if they, for example, copy the user interface of your software, or they copy the look and feel, then they cannot claim an innocent infringement defense because you put up the copyright notice. It puts the world on notice that your work is a copyrighted work. And essentially, that allows you to claim the full amount of the damages in an infringement suit. Now, the other tip with respect to copyrights is, particularly when it comes to granting licenses to your software, be very careful. Do not just use the word, you hereby license the licensee to use the work and leave it at that. You want to add a lot of clarity around the scope and the purpose of the use and restrictions around it. It is it is advised to use the language that's used in the statute, which are the enumerated exclusive rights listed above, such as, you give them the right to reproduce X number of copies for archival purposes. You give them the right to execute the software in the course of using the software, and so on and so forth. So, and the final protection tip I would recommend when it comes to copyrights, and particularly in the software context, because we're in the Silicon Valley here, is whenever you grant a license to modify or allow the licensee to create derivative works based on your software. So even if it is some level of customization that plugins that the licensee can create to use your software, think really hard whether you need to use those plugins and those modifications for in the general course of your business, and you may end up using a certain set of lines of code which will pretty much mirror the code for the particular customer who's modifying and using your source. If that is the case, keep in mind that the licensee who creates the derivative work, who's permitted to create the derivative work or the modification, owns the modified work subject to your rights in the original work. And so what you would need to have if you want to maintain and retain ownership of the modified or the derivative work is to essentially require them to expressly assign that modified work back to you in the contract, or require them to give you a very broad license which will essentially permit you to use those modifications for your other customers in the course of your business. Next slide, please, patent. So again, I will not go into this slide really, except to kind of focus on the basic protection tips, and it's really in the context of when you're licensing patents. The key thing to keep in mind here is, as a licensor licensing the patent, do not accidentally license all of your patents. Limited to the specific patents that are relevant to the licensee's use. Specify the patent numbers. Provide filing dates of the patent. This is all in order to avoid a situation where the licensee can later claim that you have licensed them additional patents and to essentially cut off your royalty stream for those patents. Also, avoid or limit granting rights to improvement based on the patents that are licensed. It is certainly something that the licensee will ask for, but it is something to be thought through very carefully and in discussion with your patent licensing attorney. And from the licensee side, for those of you on this conference call who are licensing patents, the thing to keep in mind is watch for shifting specifications if licensing the patents, just to make sure that you are actually getting all the relevant patents that you need to get licensed from the licensor. With that, I'll move to the next slide, trademarks. So trademarks are essentially, it's a word, it's your brand, and it signifies, it is an identifier of the source of your goods or services. To be very clear, domain names are not trademarks. They may contain your trademark, but just obtaining a domain name from the the registrar of the applicable domain does not give you trademark rights. In fact, a trademark owner may sue you for infringement and seek transfer of the domain name if they believe that that is going to direct or cause likelihood of confusion amongst their customers to go and look at your site for their services and products. If you have obtained a business name with the Secretary of State, that is also not a trademark. A trademark can also be a scent or a specific color, so long as it identifies the source of the goods or services. Now, how to obtain trademark rights? You get common law trademark rights just by merely using the trademark. But I always advise my clients that when it comes to trademarks, your best protection is to seek federal registration. Federal registration is obtained by making an application for the trademark or the service mark with the United States Patent and Trademarks Office. That will afford you the broadest scope of protection within the United States. Keep in mind, trademark rights are territorial, and if you obtain a federal registration, the rights that you obtain to the trademark are for use within the United States. If you want to expand your market and go international, then you need to seek a similar trademark registration in those other countries. A federal registration is valid for 10 years and subject to compliance with certain formalities and payment of fees. It can be renewed in 10-year increments indefinitely. Basic protection tips for your trademarks. Adopt a strong mark because the USPTO will not accept just any mark to be processed for registration. There are certain categories. The more unique they are, in the sense of, for example, like Apple for computers. The word Apple has no relation to computers except now as a source, as an identifier source for computers. Versus, the most generic being Apple for apples, right? So consult with the Trademarks Council and adopt a strong trademark. Then the next step would be request a comprehensive search to make sure nobody else is using that mark, and also to see if anybody has applied for that mark already with the USPTO. And then apply early for federal registration. The whole process can take between up to a year is there's no opposition to your mark when it's published. Now, other tips with respect to trademarks when you are licensing your trademarks. Avoid naked licensing. What that means is essentially you do not want to just give a licensee the right to use your trademark without specifying what sort of quality control measures you want around their use. And that is essentially to ensure that there's a certain quality with respect to the goods and services that are provided, which needs to either match your goods or services, or you need to have reviewed the quality of those goods and services so that the trademark continues to signify a certain goodwill in the marketplace. Draft trademark guidelines and consultation with Trademarks Council so that that is ready and in place. You have a consistent usage of your trademark. Next slide, please. Trade secrets. So trade secret is information that derives independent economic value from not being generally known, and is the subject of reasonable efforts to maintain its secrecy. So there are three elements that go into the definition of a trade secret. The first is that it should not be generally known, and because it's not generally known, it gives you a certain competitive advantage in the market. And third, you need to have taken certain reasonable efforts to maintain its secrecy. Trade secret protection is essentially a protection that's afforded under state laws. There is no true federal law addressing trademarks, except that there is a Uniform Trade Secrets Act, which is a sort of a model law which has been implemented in various states, except Massachusetts, New York, North Carolina, and Texas. A trade secret is protected only so long as it's not disclosed. No registration is required. And, you know, obviously the Coca-Cola secret has been around for almost 100 years, or maybe even more. And one question that I'd like to just take a quick stop here to discuss is, I have been asked often, particularly by software clients having a software business, whether to patent their software or to keep it, you know, to continue with it under trade secret and copyright laws. And the answer to that is really, in a general sense as well, is that if something is easily reverse engineerable, then protect it as a patent. If there is a significant functionality that gives you an advantage in your particular industry, then patent it. The patenting gives it protection from a functionality standpoint. And the moment you apply for, you know, go to Neal and ask him to file certain claims and patent it, you do have to make a disclosure with respect to how that functionality works. So in that sense, you know, there's no trade secret, there's a loss of trade secrets in the claim that you've made. However, you know, you might have other portions of your software or your product or processes which you can still, you know, continue to protect as trade secrets. The protection in the market is essentially if somebody copies the functionality, produces the same functionality for a functionality that's patented, then you get protection under the patent laws. If you did not patent that functionality and the other party is essentially, your competitor is essentially produced the same functionality, but they did not look at your code and they did not copy your code, then you're out of luck because they have not infringed your copyrights and they have not misappropriated your trade secrets. So there is a tremendous value in seeking patent protection, but because of its cost and you know, just the speed at which software changes, it is something that needs to be considered when close discussions with your patent attorney. And you know, at the end of the day, you are protecting your IP, your product through an integrated system. You know, patenting for certain aspects or certain functionality, copyright protection for other, fixation of the work as a work of authorship, and then trade secrets. Now, just going forth a little bit more here, basic protection tips for trade secrets. Institute a marking policy to identify and mark trade secrets confidential. Limit access to employees and contractors who have a need to know for a specific purpose and have signed confidentiality agreements. Restrict your key trade secrets, just like the Coca-Cola recipe, to the absolute minimum number of trusted employees. Maintain and access laws and educate your employees so that they don't go, chatting about it with other engineers over lunch. Use non-disclosure confidentiality agreements with third parties, always, including your consultants. Your consultants are not your employees. They are third parties, and without an NDA, they don't have any obligation to maintain the confidentiality of the IP items they come into touch with. Consult with IP counsel to include additional protective clauses based on the type of the trade secret. Here, for example, if you are giving your crown jewels, your critical source code to a developer based in India or in Europe, then what you want to do is have your lawyer essentially add additional clauses, not standard for NDA, but really going to the protection of those crown jewels. Things like they need to maintain it on a computer which is not connected in a network, in a specific location, maintain logbooks, and a lot of other protective measures. In NDA, always be watchful for what is called a residuals clause. You generally do not want a residuals clause. A residuals clause is a clause which permits the other party or the recipient of your trade secrets and confidential information to use whatever they remember for any purpose. In very narrow situations where you do have to accept a residuals clause, for example, when you're dealing with some of the largest software companies in the Valley, Intel and IBM and Apple, they will insist on residuals clauses. But then it needs to be vetted by counsel to make sure that it's limited narrowly to what is unintentionally remembered in the unaided memory of employees. Anyway, let's move on. Some IP monetization strategies. Very quickly, this goes to a general audience with intellectual property, not just in the software world, but intellectual property in their products, commodities, or their food service business, and the very different goods and services. IP can be monetized through product licensing, which is very typical in the software world, as well as the cloud business and the software as a service. It can be monetized through a sale. For example, when Qualcomm sold its semiconductor manufacturing business, that their IP was monetized in that sense from the business that they sold off. So it was a spun-off business. And then in mergers and acquisitions, obviously, the larger the patent portfolio you have, and the products that you have, the brand value, your trademark value that's there in your business, all of those contribute to increasing the value of your business as a target for an acquisition. Cross-licensing, this comes up most often when the companies are a little bit more mature and you have a larger patent portfolio and you are in an industry where you can easily trip up on using another party's patent. And cross-licensing is essentially a very good strategy where you essentially work with competitors to exchange your patent portfolio, certain patents especially, and you get the benefit of using the other party's patent, and the other party gets the benefit of using your patent. Remember that particularly in the patent world, a patent gives you the right to exclude others from using that functionality. It is not a right where you get to use that functionality. So it's an interesting aspect. Brand licensing, this is very popular, particularly in the commodity world. or in the food service business. Any business that can be franchised uses a lot of brand licensing and monetizes IP that way. As a security or collateral, when your business, and a lot of startups have this issue of liquidity, having a couple of patents in your portfolio for significant functionality and features in a particular industry can be very valuable, and you can get a loan against those patents. Other IP strategies, next slide please. There's a defensive strategy. Again, this depends on the maturity of the companies here. We're talking about businesses that have been around for 10 or 15 years, and they start to evolve their IP strategies. A defensive strategy is essentially to use patents to threaten competitors with infringement litigation. Licensing income may or may not be a goal, but usually as part of a settlement of infringement, some sort of licensing may occur, and royalties are gained through that, as well as some amount of settlement damages against any prior infringing use. You can use also patents to protect yourself from infringement litigation by countersuing or offering to cross-license patents, which is what we spoke about in the prior slide. Strategic alliance strategy. This is where companies contribute their respective intellectual property and primarily patents in a strategic alliance or joint venture to develop complex products. Another example of this strategy is when companies set up and contribute their intellectual property to a standards body to essentially create a technology standard around which to develop products. Next slide. So some licensing restrictions and issues. It's really important when you are licensing intellectual property to identify in the contract who the licensee is and whether you're granting a license to one entity, the licensee, or whether you're granting a license to one entity, the licensee, and its affiliates. If that's the case, you want to consult with counsel to ensure that the affiliates are narrowly defined and that the affiliates are bound to the license agreement. Duration, this is an important piece. If there's silence on the license term, then it may imply that the license granted is for the effective statutory term. In the case of patents, obviously, it's 20 years. Trade secrets, much longer, right, until it's generally known. And copyright as well, it would be a very long period. So watch for that. State the terms, specify that all licenses terminate upon termination or expiration of the agreement. Also, there should be, in every license agreement, there should be a lengthy clause that goes to prohibited uses. So, for example, no reverse engineering, no further distribution. There should be field of use restrictions, and so on and so forth. Usage limitations, particularly in the software world, you want to ensure that if the software is to be used only by that particular licensee in their specific business and not necessarily for distribution purposes, then you specify that it's an internal business purposes only license. Additional usage restrictions might be on use on designated machines, designated locations. There might be concurrent user limitations, and so on and so forth. Notices. This is also really important when it comes to a license agreement. Ensure that there is a clause to tell the licensee that they must reproduce the copyright, patent, and other proprietary notices and markings. Again, this goes to if anybody comes in touch with your IP, employee or consultant of the licensee, everybody's made aware that this is intellectual property owned by you, and there are consequences if they misuse it. Next slide, please. So some additional licensing restrictions when you are working with your distributors, your distributors, resellers, your strategic partners. It is really important to include a clause which tells your partner that if they contest or they challenge your ownership of your IP, whether it's your trademark or your patent, then you have a right to immediately terminate those agreements. Exclusive licenses. this is also something that is worth spending a couple of minutes on here. An exclusive license, if you're granting one, keep in mind that it excludes even yourself as the licensor, unless you clarify that the exclusive license is subject to you as a licensor being allowed to use your IP within a certain field or within a certain market, or generally. There might be some pushback from your licensee because they would want to ensure that you don't grant licenses to other distributors, but that's all language that can be worked out in the drafting process. So if you are granting an exclusive license, specify the field of use and the territory for which the licensee can use your IP. Set conditions around it, such as performance quotas and the quality. And the failure to meet those conditions should automatically, you should include a clause to automatically make that exclusive license a non-exclusive license or to terminate the license. Avoid or limit source code escrows. I do know a lot of startups, when they're doing their first deal and they are really looking for liquidity, agree to grant technology escrows or to escrow their source code. But, again, keep in mind that when you give source code escrows, investors are looking, when they do their due diligence, are looking at how easily they will lay the source code escrow, whether it was necessary to give it, and what rights does the licensee have once that source code is released to them. And so that is one clause which should always be reviewed by counsel specializing in software licensing to ensure that, number one, the licensee who's received the source code protects it and keeps it confidential. Number two, the license to the source code is limited to maybe just support and maintenance of the software that they're using, and that they cannot provide that source code to any third party. And then number three, any modifications that they make having access to your source code is assigned back to you. You just don't want them creating functionality or features and then blocking you from developing those functionalities and features in the future. Finally, avoid hybrid licensing. This is essentially, lumping all the patent rights, the copyright rights, trademark rights, and everything into one license. In most circumstances, you want to keep patents and trade secrets particularly separate because trade secret royalties will survive the patent's expiration or invalidity, and actually you can get almost 3% more royalties with respect to your trade secrets. Now, conclusion, protect your IP, which will help you maximize the value from your IP. This you should do by identifying your IP assets, and just as Neal mentioned, creating a portfolio and working with counsel to maximize and understand which IP assets should be patented, which should be protected as a trade secret or copyright. Register your significant IP assets, identify the correct IP strategy for your company based on the stage of your company's growth, as well as your industry and competitors' IP practices. Keep continuing to develop your IP portfolio, and use legal counsel who specialize in IP licensing transactions to vet and negotiate your contract and to help you maximize your IP portfolio. So that concludes my presentation.
Thank you, Satya, for that presentation. We've had several questions come in. However, we're past time, so what I would suggest is that people who have questions follow up with our panelists directly by email. The materials will be posted on royseuniversity.com, and the webinar is being recorded and will be available for replay. And again, posted on YouTube, probably as a podcast, and on Royse University. Neal, if folks want to contact you directly, how do they get a hold of you?
It's on the front sheet of the...
Your email address is?
Yes, my email address and phone number. Maybe I can spell patents@nmarcuslaw.com. It's right there on the sheet that you're seeing on the slide. That's the best way to reach me.
And my contact details are My contact details are on the first slide and the last slide.
Same here.
Okay, there we go. snarayan@rroyselaw.com. I want to thank you panelists for being here today for this presentation, and I want to thank you folks for joining us out in the audience. This now concludes our webinar.